What is up to the transparency? Good morning. It's a Thursday all day today. Yeah. Woo. All right. Idaho4 Judge Hippler yesterday unsealed over 30 documents. We're going to break them down. We're going to be using Hector. We're going to be using a lot of things. Good morning. All right, what you guys are taking a look at is 43 items were up for the prosecution and the defense to talk about and put in whether they think that something should be sealed. You know, they have no problem with it being unsealed, if there should be redactions. So what we're doing right now is we're going to be keeping track of everything. And right off the rip, the stuff that has remained sealed. So 1, 2, 3, 4, 5, 6, 7, 8 out of the 43, they're remaining sealed for the purpose of a special investigation. So things like the leak, that's going to be your red objects. Your yellow has been anything that has been redacted with the notes next to it as to why it's being redacted. And then obviously if it's a green light, it's in green. It means it's unsealed completely. So we're going to go through that. Also, for the most part, the way that Hippler, I mean, he's setting a precedent, which I think is awesome, which is we're going to get any reports that were filed, which means Nick Balance, Cyray, that stuff's coming. I know everybody keeps asking about that. So when Cyray's report is unsealed, Nick Balance's report is unsealed, that's going to be huge. So I paid attention. He went ahead and unsealed people's names that were going to be experts that people wanted to be, redacted. No, that's not happening. So the only thing that remains redacted / sealed is the stuff that has to do with the special prosecution of the leak. And then the third party culprits, they are keeping the names redacted, but anything else, no. It's just names and something that could possibly identify them. Also the date of birth. So like if there was a name of a witness in a supplemental, that name is going to be seen. The only thing that they're going to be redacting is the date of birth. So once he went ahead and did it this way, that's how it's going to be going forward, which for transparency is awesome. Also, the other thing, remember I said, man, I don't want them redacting the AV numbers and the Bates numbers. Guess what Judge Hippler said? You're not going to be able to do that, which is awesome for someone like me. People that are going to be putting it all together, going and finding the stuff in case something slipped through the cracks, things like that. All right. So with that said, let's bring in let's see. Lana, can you explain Bates numbers? Absolutely. I'll explain those actually right off the rip. So bring in Hector. Hector, what's up? What's up? Actually, we're going to do one thing out of order as well. I want to show you guys something. Okay. You guys should be seeing on the screen Bryan's apartment room. Okay. Underneath the keyboard is what they're calling a computer mat. All right. Underneath this keyboard and this computer mat. So underneath it. So you see how you see the mat? Well, underneath this mat, there was a cat hair. A cat hair was found underneath this computer mat. Let's see if I can even. You guys just see how dusty this is. I don't care what anybody says. Like this is all like you can see it on the. But anyways, underneath this computer mat does not look new at all, and it got me thinking. Where did this come from? Bryan bought everything new. Is this the only piece of material, like this computer and this mat, that he like brought with him from when he moved? But there's a cat hair that was found underneath the computer mat. So, anyways, I'm going to be looking into seeing if they determined that this computer mat, did he get it from like the school? I just find it hard to believe that Bryan would bring something into his house that was used from somebody else. Everything in this apartment is brand new. So I'm going to but I might as well bring this computer mat here and lay it all out. You know what I mean? Like, I think that, so I'm just throwing that out there for you guys. Okay. You can take what you want with it. Okay. All right, going right in order here. So anything that the parties, so based on the lack of objection, and the fact that none of the factors listed underneath, they didn't warrant sealing. So if they didn't object to it and both sides were like, we have no problems, Hippler went ahead and said automatically right off the rip, here's your order for unsealing the records which pertain to 1, 3, 6. I mean, it lists them all right here. So then what we do is we went through this and we went ahead and put the unsealing. I'm filling out actually what it pertains to, in the process of that right now. And again, those would be, if you're listening in your car, 1, 3, 6, 13, 14, 15, 16, 21, 22, 23, 24, 28, 32, 36, and 37. Again, there was no objection, so unsealing. Now, this is the order to maintain the seal status. And Hippler makes it clear that the court finds that the seal status of the following records identified in the court's August 4th, 2025 order regarding sealed documents shall remain in effect, which are 9, 18, 25, 26, 27, 30, 31, 35, and 40. And Hippler makes it very clear and says, item 9 must remain sealed as its replete is, oopsies, I'll make it as big as possible. There you go. With identifying information of the proffered alternative perpetrators, the unsealing of which would contravene the privacy concerns of these individuals and likely subject them to unwarranted harassment and reputation harm. Thus, continued sealing is warranted pursuant to the ICAR 32, I3A1 and 7. The remaining identified records all relate to an ongoing investigation. That's that. So those will become unsealed once that leak investigation is handled, because it's about prosecuting somebody. Next, these were the items listed that were either objected to by one party or both parties. So he went through and said, all right, so numbers 2, 4, 7, 10, 12, 19, 20, 20, or 33, 34, 38, 39, 42, and 43. And so those are the ones in this order he needed to make a decision, because either both sides are asking for something to have happen to that item, or one side is and the other side isn't. So he has to make a decision. So that's where you're going to get Judge Hippler making some calls, which is good for us to know, again, for future here down the road. William asked Lana, what's Bates? Well, the Bates numbers are when you're going to be putting together a discovery, you're going to start a running tally of your own material. Okay. So if you're putting something together, it may be page 1 of whatever that individual item is, but it actually has a running tally number, and that's your Bates number. So during trial, even, or during discovery talks and during the pendency of the case, hey, where's Bates page? Like, we're missing Bates pages, 7,000 to 8,000. The last, like when I'm doing my discovery request and I'm on supplemental, whatever, and I see that you, like, hey, we have Bates page, it ended on, let's say, 6,999, and now you're sending me 7,550. Well, where is 7,000 to 7,549? I'm missing 500 pages. So hopefully that answers. It's a running number, which is really important. All right. Okay, so what's nice about what Judge Hippler did here, there you go, is he wrote, so number 2, this is the date that it happened, and this is my ruling then on it. So he's giving you the number, and then he's giving you the name of the document that was filed and what he's saying about it. So number 2 is the no contact order. We're not going to talk about this. It's saying the same. The names are going to be redacted. Number 4. Is now remember, each filing, when the state says Exhibit S1, you're going to see a lot of S1s, but then it's going to have a reference, so RE. So what is this about? So this is Exhibit S1, which pertains, though, to the state's response to defendant's 24th supplemental request for discovery. This is going to be redacted. And the only thing, and the reason why it's going to be redacted, okay, is because the name of the individual identified within this document has already been widely disseminated by the media. Thus, there is no justification under ICAR to warrant the continued shielding of her name. However, the court orders that the individual's date of birth, so that's why I'm saying her name, it's coming out. So whoever name was in this exhibit, it's coming out. The only thing that we are going to redact is the date of birth. And I think perfect. In addition, the state assigned AV and Bates numbers identifying the location of the discovery is not protected work product as contemplated by ICR. So this is where I was like, yes. I'll show you what I mean. Back when we talked about this before, here is what the state wanted. They wanted, so this is request item 441 by Ann, item 442, 443, item 444. Those were her requests within that supplemental. The state has no objection, they were saying, to unsealing of this item, but request the following redactions. And right here it says, in addition, the AV should be redacted as this is attorney work product. And Hippler said, no, it's not. That's fucking awesome. Like, Hippler's like, no, it isn't. And then again, the Bates paging, the numbering. And so that's what Hippler's referring to when he says right here, number 4, that the numbers identifying the location of the discovery is not protected work product. So boom, shake your bells. All right. Next up, number 7, the second notice of filing defendant's additional / objections to the juror questionnaire. So remember, this would be the defense that said, hey, the juror questionnaire should be redacted, potentially sealed, actually, because it was going to be anyways due to the jurors. It was only going to be it was going to be circulated, and Anne wanted to be continued to be sealed because there was private matters that was discussing like mental health and stuff like that. The questions that were on there. Judge Hippler says there is nothing in this record that justifies continuing to seal under blank. Completed juror questionnaires are confidential. These were not completed juror questionnaires. This was just what the questions were. Okay. And so, but no juror filled out a questionnaire. So unsealed, boom, awesome. Awesome. What the state is doing right now is if you go to, so when you, let me go like this. Let me pull my other screen up. When you actually go over here and you see now, this is the case of interest page. When you come over here, you're going to start scrolling down like you would to go find where these items would be. They're not just putting them all back at the top. Okay. You have to, so when you're like, oh my God, why isn't anything uploading? Well, where's all this stuff at? Okay. When you're doing that, it's not what's going to happen. So if you're all the way at the top here, you actually need to go and keep up. There's one that's new. You see up. There's one that's new. Up, there's one. So you have to scroll down to find those. So just if you're somebody that's following along, they're not going to be at the top of the page because you just made a ruling on it. You're going to have to scroll to where you would find it in chronological order. Hopefully that helps. Next up. And they haven't gotten to all of them yet, for the record. We're going to go through the ones that he has listed, but there are some that still have to be put into the system. Number 12 here is the court minutes for closed session, and it had to do with the motion concerning alternate perpetrators, but they also talked about the ongoing or new investigation with the leak. So the way Hippler ruled on this was, although there is no longer a justification under ICAR 3213A to warrant the continued sealing of the entire document, there were discussions recorded within the minutes that require protection. First, the minutes at 1 hour, 31 minutes, and 52 seconds. Or, I'm sorry, rather at 1:31 p.m. I think he's doing it now. He's not doing the running clock. So this is referring to identifying information of the proffered alternate perpetrators. The revealing of this would contravene the privacy concerns of these individuals and likely subject them to undue harassment. Thus, this reference will be redacted. So like that point just in the meeting minutes, that means like your transcriptions. At that point in the hearing, it's going to be redacted. So we're going to hear all of the hearing that was closed, the closed session, except for that portion. Then there was another time that this happened, which was the meeting starting at 1:36 and 17 seconds p.m. through 2:07 and 5 seconds p.m. And that document and the discussions regarding the status of an ongoing investigation, that's being redacted, which at some point, once it is closed out, that portion will become unredacted. But right now it's staying redacted. So the prosecution or the special prosecutor, if they choose to prosecute, that person has a fair trial. Number 19, the defendant's reply to the state's objection to defendant's offer of proof, the alternate perpetrators, and the defendant's evidence in support of offer of proof. And I am going to show you guys the stuff that has been the newly obtained documents I'm going to go over because I have some really interesting finds. This number 19, obviously, it has to do with the third-party culprits. And so the way that Hippler says it's going to go down is that there is no further justification under ICAR to warrant the continued sealing of this filing. However, in the interest of privacy and to guard against likely harassment, the court orders that the names, remember the defense wanted the footnotes to remain redacted. That's not going to happen. Okay. Only the names and anything that would potentially identify them with other markers like date of birth, maybe if something was in there of their address, those things would be redacted. But those footers that were, the way that I read this is the names are what's being redacted, and other identifying information. That's it. Again, I think that's awesome. I think that's how it should be. Keep the names out of it. I just want to know the material of this third-party culprit, why these 4 people. I believe Lisa Mathis said it pretty accurately that there was a plethora of potential alternate perpetrators. And I think what she meant by that is because people weren't cleared in her terms. Like, how did you clear these people? But yeah, so we're going to get that. It's just going to be redaction of the name. So those footnotes should become unredacted. Funny thing is, if you didn't see my live yesterday, Nancy Grace and her guests made a bold statement and said that the defense team admitted, I don't know who to, but Nancy Grace has admitted to her team that the defense admitted that the third-party culprits, they weren't really culprits, and that the defense knew that they weren't really culprits, but that they were just filing that and doing that because to defend their client. And I was like, do you think that they filed that and they knew that they weren't and filed that anyways, lying to the courts? I said, Nancy Grace needs to fire that source. The defense has never said anything like that. It's very reckless. All right. So number 20 here is the state's motion to amend witness lists and supplemental expert disclosures. Again, a huge win, I believe, for transparency, which is there is no further justification under ICAR 32I3A to warrant the continued sealing of this filing. The name of the retained expert witness identified in this filing was previously revealed publicly in this case, and the unsealing of the document with the expert's name is unlikely to result in undue harassment. Consequently, it shall be unsealed without redactions. Thank you. Number 33, order granting defense expert analysis of evidence. This has not surfaced yet on the case of interest page, but it is stating that although there is, I don't know why he keeps repeating words, but although there is no longer a justification under ICAR 32I3A to warrant the continued sealing of the entire order, the court orders the identifying information, name and addresses of the expert identified therein be redacted. So this is and until such time that the court has heard from the parties regarding the privacy concerns related to the individual and makes a determination whether to further unseal the document. So remember how Judge Hippler asked for more information? That's one of those filings. Number 34 is the state's response to the defendant's motion for independent analysis of evidence. Judge Hippler says there is no longer a justification to warrant continued sealing of the filing. The sole objection was the revealing of the expert's name and address. But this information is not included in the filing. Consequently, it shall be unsealed without redactions. 38, he's saying refer to 33. And that's the motion for the independent analysis. So we're going to get that. Number 39, state's objection to defendant's offer of proof. This has to do with the alternative perpetrators. And so therefore, nothing is going to be sealed when it pertains to that. The only thing that is going to be redacted is date of birth, names, and any type of identifying information. Also, in that filing, they were asked for there was a table of contents that the state put together, and the court orders that the table of contents that listed the state's exhibits for the filing, those will be, and the exhibits themselves, those will remain sealed. So the table of contents, the actual exhibits themselves, the names, date of births, those will remain sealed. Remember, that can be appealed. And then the last one is number 42, second to last one. This has to do with the exhibit S1 to the state's response to defendant's 23rd supplemental request for discovery. This has not turned up yet on the case of interest page. I'm waiting patiently for it. But there is no further justification for this to be sealed. In addition, the redactions requested by the state will not be made. And so I was like, let's find out what the state wanted, right? Shall we? And what the state wanted with that is the state requests the following. Again, Bates pages. Item 438, they wanted the Bates pages again. There's 12 references for this item, should be redacted as this is an attorney. And they're like, nah, that's not happening. Item 49. So we're going to see that now that Judge Hippler has made a ruling like this, you're not going to see the state, I don't believe, with these next batches, even bringing this up. I don't know, maybe they just will just to be extra cautious, I guess. But once he's ruled that way, that's not happening. So, again, item 439, the pathways, 2 references, and AV numbers for this item should be redacted. And I'm like, dude, you're trying to make it so that like I can't like reconstruct this whole damn thing if I wanted to. That's basically what that's all about. And Judge Hippler said, go F off. That's not happening. The potential witnesses and their names identified in this item should be redacted. That's what they were also asking for. And again, this was item 42. And Hippler says, unsealed without redactions. 43 is the Exhibit V to defendant's 23rd supplemental request for discovery. So this would be Ann Taylor. She was listing all of her exhibits. You know, if it was supplemental 1, it was A, you know, A, B, C, D, E. So 43 had to do with that request. And he said, refer to 43 or 42 rather. And so it's the same ruling that means, and it will be unsealed. And now, so those are all the filings that happened with the first batch. So seal or no seal. After Judge Hippler put all that in, okay, he then said, I'm giving you guys the second batch of my seal or no seal. And he's basically doing it in months. So how I've give you guys a sneak peek at this, which is, it's going to be, it starts at the end of May. And so it includes all of May. And all of April. Okay. And some of the big tickets that are coming on this next batch is the tip, what they stipulated to on this tip. That's one of the items. That's what I'm most interested in. And that's item 61, which was the joint proposed jury instructions regarding the tip leading to the investigation of the defendant. Another big one is number 80 and 81, which are the state's trial brief and the defendant's trial brief. Okay, this is their outlook on the case. This is huge. Okay, you make a trial brief. It's stating basically your case. All right. They had to file those in April. So 80 and 81, that's the state's trial brief, the defense trial brief. Number 84 is Exhibit 4 in support of defendant's objection to state's motion limine, which is the AT&T timing advance. That's a big one. So those are the ones I'm most looking forward to. I'll go over those right here at the end of the show to tell you what you can be expecting. Now, based off of the rulings, we then got new documents. First document I want to talk about is Bryan Kohberger's written, look at that handwriting. This is going to be what he filled out by the defendant, his initials for his questionnaire with his plea deal. So right here is your questions regarding the ability to enter a plea deal. For the sake of saving my voice from going through crazy town, I'm going to point out what I believe are just the most significant things. Do you read and write the English language? I'm sorry, like questions like that, I'm not going to read. Okay. I was shocked. I wrote a community page or post about it. I was shocked when I found out that what Bryan Kohberger wrote for number 6. Question: have you ever been diagnosed with a mental health disorder? His answer was yes. If so, what was the diagnosis? What were you diagnosed with, and when was it made? February of 2025. Autism. What? OCD. What? ADHD. What? And then a health eating disorder. What? I'll make it very clear that I'm of the opinion that when you have a child and they are from the ages of being born to 18, we as parents are responsible for our kids, right? We get vaccinations for our children. We care about their, oral hygiene. We take them to the dentist. We take them to the doctor. I wrote this in a post, and up until your child is 18 years old, you're supposed to be doing everything that you can to protect them, right? To nurture them, to guide them, to take care of them. All right. And that most certainly has to do with mental health, which dealing with their teachers, right? Getting them in school, helping them with home. I mean, everything. Like you're boom. And it's my opinion that when the mitigating phase and the sentencing phase needed to be talked about, and that portion of defending Bryan Kohberger, that's when things got difficult. That's when it was like, wait, you want to talk about if I was to get found guilty, you're going to use in the sentencing phase, basically in blaming his parents. That's where I think that this was headed. And Ann Taylor is probably explaining, well, Bryan, we're trying to save your life at that point, right? And we're going to use anything that we can in the sentencing phase so that doesn't happen. but that's also going to bring out a lot of, I think Ann Taylor was talking about red flags, and that we didn't know some things. And then she was talking about, well, the cooperation from Bryan wasn't there, like it was maybe in the beginning, because you're talking about the other part, the guilt phase. So people that are out there saying, why would Bryan Kohberger take a plea deal? They really need to look at that portion, because that's what was happening towards the end, and before the plea deal. So if you haven't seen that post, I recommend that you go see it. For Bryan Kohberger to have ADHD, which usually tends to lead to like focusing, and for him not to have take any type of medication, I'm just curious what he did to be able to accomplish where he's able to focus, retain the information that he's learning, take his tests, get his grades, get his his good grades, and be able to be successful in that part of his life. That would be interesting to me to see how he was able to, if he's saying that he was never diagnosed with that, never medicated for that. I know a lot of people that have ADD, ADHD, and a lot of people that don't find out about it until they become adults even. And they're like, oh my God, thank God for this, because it helps me so much to focus on something. I'll make to-do lists and I don't finish my stuff. I'll start something, I never finish it, those type of things. So I'm just interested in that. But this also tells me that there would be no documentation. So the people that would have been at WSU and anybody that could have looked at his files to see, like, that he presented as having autism at any type of level, that wouldn't have been there. That just wouldn't have been there. So it couldn't have been something that it could have leaked in any type of way. Nobody would have known about it because it's just never been documented. So that was just interesting to me. Then when I saw what medications he was taking at the time, I looked up what this was and I was like, okay, this is for thyroid, this has nothing to do with what I'm thinking of. Like, okay, well, did they start having him say, okay, hey, since you have ADHD, maybe he's just like, listen, I've gone this long. Like, a lot of people don't believe in medications and they're like, I'm not taking anything. I don't like taking medications. I don't want anything. I'm fine. I've gone this long, whatever. But yeah, that's the only thing that he was taking, which was 100 milligrams of, it was for thyroid, his thyroid. So, boop, boop, boop. All right. The rest of it is pretty much everything that Hippler asked him when he was filling. If you go through this and fill this out, everything that pretty much we saw, Hippler did a really good job of going over it, asked them these questions. I understand that by pleading guilty, I am waiving my right to a speedy and public jury trial. Well, he already waived the speedy part, so. I understand that by pleading guilty, I am waiving my right to question, which means confront the witnesses against me and present witnesses and evidence in my defense. Number 7 here, the state has the burden of proving you guilty beyond a reasonable doubt. I understand that by pleading guilty, I am waiving my right to require the state to prove my guilt beyond a reasonable doubt. Is your guilty plea the result of a plea agreement? Okay. So Bryan Kohberger and Bill Thompson have a difference of opinion here. Bill Thompson, who, oh my gosh, I'll be talking about it tonight, guys. Steve and Chrissy did Christy did one of the best interviews that I think that they've ever done since this whole tragedy has happened. It was on Nancy Grace, and I think they did it a couple days ago or whenever it was, but she just broke it up into two parts. And because I was criticizing, like, let them speak. You know what I mean? Don't interrupt them. Don't edit it. Let them speak. And so that's what I'm going to be talking about tonight. Dude, Steve and Christy literally light Bill Thompson and his fucking team the fuck up. Light them up. And I loved every second of it. It's the truth. It's these people lied to these people. They lied to the parents. They've been lying about so much shit. And I said, Bill Thompson, they did the plea deal, you guys, to protect his legacy, his career, other people's careers. And when I say their jobs, legit their jobs. Okay. That trial would have exposed a lot of shit. Regardless if Bryan's going to be found guilty or not, I'm saying that people in the way that they did things, the old Ohio way or the Idaho way, that's, yeah. So he took saving, in my opinion, things like that, over going and doing what you promised you were going to do for the victims and their families. And Steve Gonsalves calls Bill Thompson Santa Claus and calls him a clown. And I'm like, oh my God. If he'll just say backseat Bill, it'll be the trifecta. So tune in tonight as I break that down. Going back to here. So is your guilty plea the result of a plea agreement? Bryan Kohberger says, yes, it is. Bill Thompson says, this is not a plea. This is not a deal. Okay. This is not a deal. And Bryan Kohberger's like, this is definitely a deal. And if so, what are the terms of that plea agreement? And he says, see attached. So, has your attorney, number 19, has your attorney or anyone else forced or coerced you in any way into accepting this plea bargain? Bryan Kohberger says no. Okay. Have any other promises been made to you that have influenced your decision to plead guilty? No. Number 21. Has anyone told you what your sentence will be? Yes. Okay. What? 4 fixed life sentences, consecutive, without the possibility or potential. He uses potential for parole, as well as 10 years. Then they get into the appellate rights. So is this a conditional guilty plea in which you are reserving your right to appeal any specified adverse ruling? No. What rulings have you reserved the right to appeal? He could have wrote these things down. He said none. I think I now know why Ann Taylor tried so hard. Also, I mean, obviously it's her job to get the death penalty off the table, but she knew, I think, Bryan saying that I wasn't going to go to trial then if this is what we have to do and talk about these mitigating, this sentencing phase part. Because every chance she got, Ann Taylor was, I just felt like it was overly done at every chance, putting in the filing somewhere like, well, if you just take the death penalty off the table, because that's my question, is does this go to trial if the death penalty is on the table? Um, Your relationship with your attorney. This is the last part I'm going to talk about here. And that is, have you had sufficient time to discuss your case with your attorney? Yes. Have you had adequate time to fill out this form? Yes. Have you had adequate access to your attorney's assistance in filling out this form? Yes. Your attorney can obtain various items from the prosecutor relating to your case. This may include police reports, witness statements, taped interviews, photographs, reports of scientific testing, etc. This is called discovery. Have you had the opportunity to review the discovery provided by your attorney? Have you, not has your attorney, have you had the opportunity to review? Have you had the opportunity to review the discovery provided by your attorney? I can't even believe, like, that's a lie right there, because it's not reviewable in the amount of time, right? So I just think that that's interesting to ask that type of a question and say, I've had the opportunity to review everything. There's no chance in hell that happened. It's just not enough time. And then, if it is not a conditional guilty plea, do you understand that by pleading guilty, you are waiving your right to appeal any ruling made by the judge prior to entering your guilty plea? That means everything leading up to it. Yes. Have you waived? So Ann Taylor would have been sitting there saying, Bryan, this is what this means. Even if I think that you already know what it means, I'm going to tell you what it means. Have you waived your right to appeal your sentence as part of your plea agreement? Yes. And then he writes, potential sentence. Count 1, count 2. Do you want your attorney to take further action in this case? No. If you are not a citizen of the United States, have you talked to your attorney about the impact of your guilty plea on deportation? He's like, oh, wait, I don't have to answer that if you are not a citizen of the United States. Do you understand that no one, including your attorney, can force you to plead guilty in this case? Yes. Are you satisfied with your attorney's representation? Yes. They did not have mediation. There was no Alford plea. And then closing it out, do you understand that if the court accepts your guilty plea or pleas, that you may not be able to withdraw your plea or pleas at a later date? Yes. Is there anything else you want to tell the court about why you are pleading guilty? No. Have you discussed the elements of the offenses with what you're charged with your attorney? Yes. I have answered the questions on pages 1 through 7 of the guilty plea advisory form truthfully. I understand of all the questions answers herein. I've had the opportunity to discuss each question and answer with my attorney, and I have completed the form freely and voluntarily with a complete understanding of the charges to which I am pleading guilty and with knowledge of the potential consequences of this plea. And it's dated 6/29/2025. And so there's Anne, Becca Barlow, Lisa Mathis. Okay. One of the other unsealed items here is the opposition to the motion to vacate the non-dissemination order. For the most part, we saw this, except down here, and this would be on page 4. The court has issued a records hold order, and a special inquiry is ongoing. Okay, and that was about the leaks. There's a this was added because after Bill Thompson says that they have no objection to, at first they were like, hey, we want to keep the non-dissemination order in place. Then they came back and they said, they filed and said, we have no issues with it being actually, lifted. And so Ann Taylor adds this part in, which was the state, in its response to the media's motion, the state now withdraws its request for the non-dissemination order to be continued until sentencing. The state cites, in quotes, further reflection, and continues that out of respect for the integrity of the judicial process and the privacy of the victims and their families, as they consider their rights to provide victim impact statements, and at sentencing, the prosecution team, and that's what Anne highlights and puts a footer, and I'll read it, that the prosecution team, and this is footer 5, does not intend to make any public statements about this case until after sentencing has concluded. And the state's promise rings hollow given the previous leaks from the sources close to law enforcement. Okay. And this is the part that was taken, like, redacted, I guess you could say. And here it is, which is from the language, who is quote unquote promising not to speak to the press is vague. Does this mean the attorneys, staff members of the prosecution's office, and or all of the 150 law enforcement officers involved in this investigation? On July 2nd, 2025, an entire row in the courtroom gallery was occupied by law enforcement who were watching the proceedings. Will a third of the courtroom now be allocated to law enforcement free to provide media interviews as they enter and exit the courthouse? One of the new documents here, next up, is the order, and this was for Ann Taylor and Ashley Jennings filed a joint stipulation to allowing 2 new exhibits. Okay. And those 2 new exhibits was right here. This is new. This is the stipulated motion to the admission of additional exhibits as evidence at trial. And this was conditional. And Hippler is saying, well, the reason it's denied in part basically is because he's saying it's denied because this evidence will not be admissible until it's offered with the appropriate witness at trial, as this was explained at the pretrial conference. And what this is in reference to is to FBI lab reports, Exhibit 1 and Exhibit 2 here. The first one is the unredacted portion, and the second one, it's saying that this was, well, one's redacted, one's unredacted. Both of them were unsealed. So I went through this, and I found some stuff that was interesting. So let me just back up just a little bit. Well, we found out who Karen Lowe is. Remember I was like, we have no idea who Karen Lowe is. Well, we found out who Karen Lowe is. Karen Lowe works for the FBI. Karen Lowe is the person that wrote up this report. And she is trace evidence member of that unit, Karen Lowe. Dude, so many people on that list attached FBI next to their name. And so this was communication that was had. This was to Travis Shirley. Date was January 27th, 2023. And it was, the communications began January 4th of 2023. And it has to do with the trace and the hair fibers. So this document may contain privileged information. And there were, when you go through it, '61 items. 61 items. And the first part of this report that Karen Lowe wrote up is, this is your methodology of how she did hairs and she did fibers. Okay. And this was the result of the trace evidence examinations, the hair and the fiber. And it's from out of these 61 items that came from Bryan Kohberger's apartment, 1122 King Road. And either it was something of items that the victims had on them, it was a part of the house, debris that was found. Then at Bryan Kohberger's apartment, there was a cat hair found. So I'm going to go through what the findings were and point out just what the interesting parts were. So she lists her methodology, and then this is what she would have been testifying to. And these are the results of the examinations. And so those results of the examinations, which was number 1, and these are the items submitted from Ethan, Santa, Kaylee, Maddie, and it said next to them what the item was that pertained to them. Real quick, this would be items that were taken from the scene. So a head hair sample from Ethan. You can see the whole list down. There was necklaces, bracelets, rings, the fake eyelashes, earrings, the comforter. It was actually preserved. They didn't do anything with it. They preserved it. They preserved her fake eyelashes, Maddie's fake eyelashes. They preserved those. Now here's where I highlighted the stuff that was interesting to me. Item 21, item 22, and item 23. This was, and I'm going to say it, debris. It's debris, guys, but you know why. Nothing like a debris party. Debris from near northwest bedroom on second floor at 1122 King Road. Item 22, same thing. Item 23, from half wall leading to northwest bedroom on second floor. Item 24 is the debris from the door of the northwest bedroom on second floor at 1122 King Road. What was on that door? Maddie, that would be Xana's door. Then you get to item 26, which was the debris from under the computer pad on the desk in the bedroom at Bryan Kohberger's apartment. And that's where they found this cat hair. And I was like, geez. I was like, I find it, he bought everything new in there. And then he's just going to roll up this pad. And so I showed you guys earlier the picture. I'll show it one more time here if you're just joining. Here is the picture. Pick picture. So this used pad, computer pad, your mouse pad, and then you can really get a good look. Go look for yourself through these photos. But this is, this hasn't been used, man. But that cat hair is really interesting. You're gonna buy all this stuff that's brand new, but yet you're gonna bring this beat up computer pad and then just set this computer up like, I don't know, for what show? Because you definitely didn't use it. Look at this. Anyways. But there was a hair found underneath this mat, a cat hair. And so that was number 26. They saved and they preserved the broom that was in Bryan's room, item 30. They preserved what was on that broom head. Okay. And item 47, the blanket from 1122 King Road. I'm curious of what they mean by when they say the blanket. Is that, and I was paying attention to this number here, 1811. See, like 0075. I'm curious if that's the pink and white heart blanket. They preserved the right handbag from Maddie. Number 61, the vacuum container from 1630 Northeast Valley, his apartment. They preserved that. So how I found that out is by reading. And so I just went through and connected the dots and wrote things where they needed to be. But for the first part here is all the items that were tested from the victims. They were tested and examined for hairs microscopically to see if they were consistent with hairs from Bryan Kohberger. And that answer is none were found. So on any of the items that they tested, they pulled Bryan's hair out of his head as well as his arm hair, and nothing was found. Then number 2 here is items submitted from the apartment, which was items 26 through 30, and then number 61. They were examined for hairs microscopically consistent with hairs in the head, for example, of the victims, and none were found. Animal hair, then number 3 here. So the stuff with the broom, the stuff with the vacuum, they preserve that. Number 3 here is animal hairs consistent with dog hairs found in items 61. Okay, so there was dog hair. Item 61 would be when the vacuum. Okay, so think about this. If he was always, remember how his neighbors were talking about, well, he was always vacuuming or cleaning or something like that, running the vacuum. Remember that? Obviously, this apartment that Bryan Kohberger moved into when he got to WSU was not like a brand new apartment, never been occupied by anybody, right? Wrong. It's been there for a long time. Bryan Kohberger doesn't own a dog, right? Bryan Kohberger, I don't know, he had a dog back at home. I want to hear more about that. But for the dog hair to have been in the vacuum that they went through, that's at the apartment complex. All right. Did he buy that vacuum? A lot of people buy, you think he traveled with a vacuum? No, I believe that he probably bought that vacuum when he got there. Like, that's what you do. So the dog hair is not consistent with Murphy. Who's this dog hair belong to? Was there any items in the vacuum that were consistent with Bryan, though? Were any of his hair found in the debris? In the debris? You know what I mean? Think about that. Like, did they test? Hey, did you guys find any like Bryan's hair? You know, if you come to my house and you went through stuff, you're gonna, oh yeah, look at this is all like this Yep, we found Lana's hair in the vacuum. Clean, you know. So I'm curious, did they find anything to do with Bryan in that 61 item, which was the vacuum? I would expect you know, people are saying, well, maybe his dad brought the dog hair. Well, did the dad go in the apartment? Did the dad go in the apartment? Is it consistent with Bryan's, you know, dogs at Pennsylvania, and that's how it got transferred? Again, just one hair, guys, one hair. No offense, but I would expect more than one hair. If my dad came from a house of mine, from home, and that all he was able to possibly track in my house was one hair. And you know, they always said he was vacuuming, cleaning, and so just one piece of hair was able to make it through. I would just think it would be interesting if there's nothing in the vacuum that is of, hey, that's Bryan's hair. We also found, we found 9 pieces of, here's 9 hairs. Yep, 3 of those are Bryan's. What if nothing in there was Bryan's? Wouldn't that be interesting? Okay, so they took hair from Murphy, and that was item 44. So accordingly, Murphy cannot be included as a possible source of these hairs. Number 4 here is an animal hair consistent with cat hair was found, like I told you guys, item 26, is of limited value for meaningful microscopic comparison purposes and has been preserved for possible future comparisons. And I was like, this is from the desk of Bryan Kohberger, specifically underneath the computer pad. And this is my reference, but you guys can take the notes as well. If you have the 500 or the 699 pages or however many it was, 599, whatever it was, it's page 404 where you get a good look. And it's the pic of his apartment. Next, additional debris collected from items 3, 12, 13, 15 through 20, 30 through 43, and 47 through 61. They have been preserved. So that's why I wrote preserved next to those items. Interpretation. It's a very interesting one. Again, Karen, if she was called to the stand, her interpretation of everything is hairs may be characterized and classified accordingly to their morphology. The first step is to determining whether the hair is of a human or animal. Okay, non-human, where's the origin? Then she's saying that animal hairs can be then further classified into the type, the fur or guard, and the type of animal like dog or cat. Human hairs may then be further examined for characteristics. So I think we know this, your ancestry. So is it, a white person, black person? And then where would the hair be found? Is it pubic hair? Is it hair from your head? Things like that. She's saying then things can be broken down. It should be noted there is the potential for hairs to be classified into, again, this is going into the ancestry, which may not correspond with the individual's outward physical appearance and or how an individual identifies their own race or ethnic group. The characteristics exhibited in the hairs are used as the comparison criteria. So when the presence or absence, appearance, and distribution of characteristics exhibited in a recovered hair and represented in the known sample, the source of the known sample can be included as a possible source of the recovered hairs. Microscopic hair comparison are meaningful due to the variation in the macro and then also the microscope characteristics between individuals. However, the comparison of the hairs and their characteristics does not constitute a basis for personal identification, and the number of individuals who could be included as a possible source of the specific hair is unknown, because I could have had your hair on me and then went to his apartment, and then now your hair is in his apartment, but you were never in his apartment. Get it? Good. Great. Awesome. Fibers. So she's talking about the hairs now. Fibers. They can differ as to the type. So is it, rayon, cotton, and then you have the different color, the shape, the size, microscopic features, and optical properties. These are characteristics that may associate fibers with a group of items, but never to a single item, to the exclusion of all others. However, even fibers with many similar properties may be excluded as originating from that same source by using the identified analytical method. The inability to associate persons/items through microscopic hair/fiber examination does not necessarily mean the persons or the items of interest had no contact. A number of factors can produce this result, including number one, hair fibers. That evidence may not have transferred. Number two is hair fibers that did transfer may have been lost prior to submission to the laboratory. Number three, the hairs or fibers transferred or the known sample submitted may not be representative of the source. And number four, the hairs/fibers may be from a different source. Further questions about the content of this report, please contact her, okay? If you guys have any questions. So basically, it just, this is the clip from it. Basically, I'm here to tell you, if you're, Karen Lowe is going to go out there and say, listen, the lack of any of this doesn't mean that this person didn't come in contact with these people. And that the lack of those things does not mean that they say that Bryan Kohberger isn't the one. And was going to testify as to why and how and stuff like that. And I thought this was going to be interesting, but we didn't get to hear it. Now, as you can see, this date here, February 28th, 2023, that was January. And this was the second exhibit. It looks the same. But it's not. Because this one has to do with everything from the car. So with the exception of items 2, 5, 7, 11, 44. Okay. Items 65, 66, 67, all the new stuff, that's going to start from the white Honda Elantra. Okay. And this is where they took everything from the car. So again, if you all remember this, Jennifer Coffendorfer, a lot of people came out and said, oh, they can't wait to get that car. It's going to light up like a Christmas tree with all the shit that's going to be in there. And this car had nothing. The apartment had nothing. As you can see, I asked the question yesterday, why didn't they take apart the bathroom of Bryan Kohberger's apartment and get into the pipe, the drain? They did it in the Matima case in Virginia of the missing mom, the Indian family. They didn't do it here. shocking. Like, just wow. So they vacuumed and they did the sweeping from the seat in the compartment A of the Elantra, the vacuum sweepings from the seat in compartment B, vacuum sweepings from the floor in compartment B, the vacuum sweepings from the seat in compartment C, the vacuum sweepings from the component C, which was from the floor. Then D is a different compartment where it was the vacuum sweepings from the seat. Probably you got your passenger, you got your driver. So they're listing all these compartments, and there'd probably be a diagram to tell you what that would refer to. But this is everything that they took from, now we get to right here, which is, now it's the house. So items 76 down is the parts from Bryan Kohberger's parents' place, which is pants from the laundry basket on TV stand in room K, shirt from the laundry basket, sweatshirt from the laundry basket, jacket from the laundry basket. And then she's saying, okay, here the results of the trace evidence examination. So here's the report. And remember when Ann Taylor was talking to Judge in the beginning, she's like, you know, there is nothing that ties my client to the victims, you know, and she mentions the results of all of the search warrants to do with his apartment, his car, his parents' place. And if you look at the dates of these reports that actually coincide with Ann Taylor would have had this, and this is where she's calling it from. These reports were done in 2023. So January 28th, 2023. This one was done a month later, February of 2023. So if you go and you look back why Ann Taylor is saying what she's saying, it's because of these reports. The results. So the items submitted from the Elantra, items 65 through 75, and from the house, his parents' house, 119 Lamson Drive, that would be items 76 through 80. Those were examined for hairs microscopically consistent with hairs on the head samples from the victims. However, none were found. Animal hairs consistent with dog hairs found in or on items 67, 70, 71, 74, and 76 through 80 when they were microscopically examined. Murphy cannot be included as a possible source of these hairs. So based on the item sample from 44, which was they went and cut Murphy's hair in January, and it says that Murphy cannot be included. Murphy's out. None of the dog hair is Murphy. Additional debris from items 65, 67 through 80, they have been preserved for possible future comparison. Interpretation again. She's going to break it all down like she did what we just read. And she's basically going to get up there and say that just because that stuff isn't there doesn't mean, and that's when she talks about this, the inability to associate a person or items through the examination does not necessarily mean the person or items of interest had no contact. A number of factors can produce this result, including the hair or the fiber evidence may not have transferred. Hair/fibers that did transfer may have been lost prior to admission to the laboratory. And I just believe that when all this stuff starts coming out, remember Ann Taylor said there was also, not only was the stuff not present, there was no trace, there was also no signs of a cleanup. Where's that? Where's that report? That's not in here. The signs of a cleanup. Yeah, she can say all these things, but if I was on a jury, how my common sense would operate is that the number of things that you tested, that's what's going to outweigh, hey, just so you know, this is why, though, sometimes that stuff could be missing. But there also wasn't a sign of a cleanup. So where's that? Because I know that Bill Thompson had told all of us that the car was in immaculate condition. And all I can tell you is that car from the outside looked dirty as hell. And if this person's saying that they were able to get stuff, I would like to see what that stuff. I mean, she's saying that there was stuff in there. I don't know. And then finally, well, there was 25 pages put in, and then 12. Okay, so Christian Westring. Remember, we were looking up all the people. We found another name. We told you who he was. We weren't wrong. He was going to be testifying to DNA for the state. Okay. And I'm just going to tell you what I learned from this. What's new. He put in a 25-page affidavit, which the beginning part describes literally DNA to like somebody like Hippler's like, hey, we're going to talk to you guys about DNA. So you better have somebody that's going to present this to like a first grader. Okay. That's the first part of his affidavit. Things like the fundamentals of human DNA testing for forensic applications. Fundamentals of human DNA profiles and their interpretation. Then you get to the second part of his affidavit, which is opinion in regard to DNA analysis conducted by Idaho State Police Lab and cybergenetics. The following describes my review of the DNA testing in the matter of Idaho versus Bryan Kohberger. As part of my analysis, I have been provided materials. Well, I would like to know what materials, right? I have been provided materials from the Latah District Attorney's Office, William W. Thompson, backseat bill there, relevant to the matter for my review. As part of the forensic investigation, I have been asked to address the following 3 questions. So his purpose of what he would be testifying to is when we're in a trial and someone's like, why didn't that expert do whatever? And why didn't they get that phone? Why were they just... This is what this man was asked to do by Bill Thompson. 3 questions. Number 1, what is the definition of inclusion, exclusion, and inconclusive as it applies to forensic DNA analysis? And why do laboratories set different ranges/criteria for their protocol/purposes? I believe that this is going to be a rebuttal witness. Just my gut tells me. Because Miller was going to be the witness, Jade Miller, who testified at the grand jury. And then I believe that the defense had somebody that was going to talk about this likely ratio as far as like underneath the fingernails and stuff like that. And then what this guy is for is he was going to come in and do the rebuttal, okay, to the defense's expert that was going to, kind of go ham on the terminology, and it's not being presented right to the jury, and this is why you need to say it this way type of thing. So this was like the rebuttal. That's how I see it, and that's why it was towards the end, which makes sense when we're going backwards. Question 2. So this all had to do with the fingernails, number 1. Question 2 was, what are the substantive differences between the analysis conducted by the Idaho State Police Lab employing the STR mix software and the subsequent analysis of the Idaho State Police test results conducted by Cybergenetics employing the True Allele software for item 13.1? And then number 3, what is his so he says, what is my independent opinion regarding the Idaho State Police Lab DNA results for item 13.1 as it pertains to the complexity of the DNA mixture obtained and conclusion reached? And remember, this is his like report. Okay. So when they're ever asked, like, would it help to refer to your report? This is what they would have. Also, it's an evidence. You'd have to testify to it. This person would be called to the stand. The only way that the jury would ever see this, like, you're admitting all of this shit. So here he breaks down question 1. And I know that this has to do with the fingernails because this is what Jade Miller was talking about, which is so you'd want to see Jade Miller's report. And this is his definition of inclusion. This is his definition of exclusion. And this is his definition of inconclusive. He's going to cite the NIJ, so he cites publications. But he says exclusion or non-match. When comparing a known sample to an evidence sample, the donor of the known is excluded as a source of the evidence if the profiles are different. This can either be referenced to as an exclusion or a non-match. So he's saying that non-match and exclusion are synonymous. When an individual is excluded as the source of DNA, it does not necessarily mean the individual was not involved. For example, a true perpetrator who left no detectable biological material will be excluded as a source of DNA. When addressing the potential for inconclusive results, he's using SWGDAM interpretation, and those are the guidelines. And so he's citing that 2017. So the laboratory shall establish the guidelines for inclusionary, exclusionary, and inconclusive. And so what he did is he was, again, told to take the Idaho State Police work. And so they did all of this. What do you take from it? And he says that they were using these numerical references, and there can be different numerical references. And so therefore, based on what the Idaho State Police Lab and their numbers and their range, he's saying that he has no problem with it. And you get that at the end. And he says it because right here. He's saying that, therefore, the numerical range of the term inconclusive was clearly defined in the Idaho State Police protocols based on the internally derived validation data and was correctly used by the Idaho State Police lab in this case. So that's how the decision to use an inconclusive range for reporting likely ratios varies between laboratories. Some scientists may reasonably disagree with the application of inconclusive range when reporting likely ratios, while others readily accept it. Each laboratory sets their procedures, which they must follow, while somewhat conflicting. And so he's citing that again. And remember, this has to do with the fingernail clippings under Maddie's, the DNA, the potential sources under the clippings of Maddie's fingernails. And so obviously you're not going to go get somebody out in the field that's going to come in and say, yeah, Idaho State Police lab is shit and this is fucking bullshit. And yeah, I side with the defense. You know what I mean? No. So this report, and that's why it's a rebuttal to whatever Ann Taylor had, and to say, yeah, no, I stand by the Idaho State Police lab and how they did it, and this is why. And I think when it comes to experts, they kind of like, what's the word I want to use? They cancel themselves out. If you are respectable and hey, this is my expert opinion on, and it could be this way, and you present it well, okay, and then this person comes in and same thing, they have their credentials and they present it well, they're going to cancel themselves out to me. Like it's like a no harm, no foul type thing. But when you don't have, I think, an expert from the one side or the other that's clashing with it, then that's where it's going to hold way more weight. Makes sense, right? Interesting, in the Delphi case with the bullet, right? That was the only piece of physical I considered evidence, and they dismissed it. And they said that they didn't think that Richard Allen's gun was that bullet casing, or not the bullet casing, but the actual bullet. And I'm like, what the hell? Then how did you find this man guilty? Jesus Christ. So it's, in a lot of this type of testimony, you're going to lose the jury because they don't even fucking know what you're talking about, right? So experts, to me, I would want relatable people to the jury that can break it down and can explain whatever it is that you're talking about. So yeah, at the Delphi case, it was an unspent round, so it had went through. They said it exited, and all the juries over here like, yeah, no, we didn't think that it looked like it. We didn't think it was a match. I'm like, oh my god, then what? That's basically what they arrested him off of. So yeah. I also think that the defense in this case, they were trying to make it so that Jade Miller wasn't able to talk about certain things. Remember the motion lemonies? So that was going to come up again. And so he was, like I said, they went out and got this dude. I mean, he's stacked. So the Idaho State Police Laboratory concluded that the analysis was inconclusive with regards to Bryan Kohberger, in accordance with their published SOPs. So a policy to apply an LR threshold, likely ratio threshold, on 0.01 to 100 is balanced and neither favor one side or the other. considering the SWGDAM scale of verbal qualifiers for reporting likelihood ratios. That's what LR means. The reciprocal of the LR of a 0.046 calculated by Idaho State Police provides limited support for the defense's proposition. This reflects the probability of the DNA evidence being 25 times likely if the DNA originated from an unknown, unrelated individual than if it originated from Bryan Kohberger. So that provides limited support for the defense proposition, which we don't have yet. That's what kind of sucks with going backwards, I will say. Like, we don't have this yet of what the defense's proposition is. So when these are getting sealed or unsealed backwards, and I think I'm going to kind of flip on how I do this and wait till I have certain pieces that I would need to show stuff, because I think it matters when explaining it and wanting to see it. Because what's the defense's proposition? Well, I don't fucking know, because it's not it's not been unsealed yet, you know? But hey, at least we're going to get the material. Based on my independent analysis of the data generated by the Idaho State Police Laboratory, Bryan Kohberger was excluded as potential contributor to the mixed DNA sample obtained from the body swab collected from Madison Mogen, 13.1. The likely ratio was calculated for the DNA mixture relative to Bryan Kohberger, but was not necessarily based on the qualitative assessment of the alleles detected relative to Bryan Kohberger. The likely ratio calculator provides further support for HD. So, again, that would be the HP versus HD, which if you back up to unrelated individual is HD. So it's unrelated individual. Well, Heather, that's what I was going to say. But I was like, you know what? I just want to wait till I get the material. But that's basically what it's going to say. Yeah. Unless their proposition is something about being a relative of Bryan Kohberger or something like that, which I can't imagine that's what they're going to be saying. So, again, this was because of 13.1 was the underneath. This was the fingernail scrapings from Maddie, and there was like it was a mixture of like 4, and so they used 2. They couldn't exclude Maddie and Kaylee as being one of the 4, and then how they determined like the other 2 people. But Bryan Kohberger was excluded, and then it was like, well, no, it's just we can't say the word excluded. It was inconclusive. And then I believe that the defense went and did their own thing, and then this guy is like that rebuttal. So that's how I am understanding it, but we don't have that yet. So, yeah. And this is just his CV, his affidavit, his CV. That's all that was unsealed. Yeah, that's everything. But definitely precedent was set here with his rulings. And then finally, I said I would close you guys out with this is the second batch. I want to see I can't wait to see these, the juror questionnaire. Actually, let's take a look. No, they're probably not in there yet. Okay. Here it is. Remember, it's going to be all of April and all of May. And so going backwards, item 44 is the parties proposed stipulated jury instruction. 45, state's proposed supplemental jury instruction. See, this is where you're getting into the sentencing phase. So your mitigation witness list, the penalty phase experts, a rebuttal disclosure, defendant's evidence in support of offer of proof. That's going to be sealed, except for their names. Number 51 is objection to the court's request for the defense to submit a redacted copy of ex parte filing to the state. 52, Exhibit F for the defense this is to answer the state has questions with their discovery, and so the defense is labeling theirs, A, B, C. So this is the F1 for the sixth one. The defense objection to the juror questionnaires. Remember, they had to both propose their jury questionnaires, and they kept on going back and forth. This court minutes, this closed session. I think this is, if I'm not mistaken, I think this is when everyone was sat down for the leak for Dateline. Like the parents and stuff were in on Zoom. And that's kind of what Steve talks about a little bit. So give you guys a little preview of what I'll be talking about tonight. It was absolutely glorious to see.
He can communicate with the outside world.
There are going to be a time for you to struggle and be a victim, but if you can rally up and then go into that system and say, and demand justice, and demand that your child is treated as fair as possible, and you'll feel better when it's all said and done. It's never going to bring them back. And I literally had a judge scream at me, we're not going to bring her back. And I was like, that's not what this is about. This is about you guys doing everything by the book.
Wait, the judge told you you're not going to bring her back?
Yeah. Yelling at me, telling me he didn't want me to talk to the media anymore. And I said, well, that's not going to happen. I'm going to talk to the media every single time I want. He basically said, well, then we'll never have a trial.
Yeah, he in a closed hearing.
I can't believe a judge told you how you're supposed to behave and you can't bring her back. That is not appropriate for a judge to tell a grieving parent, you can't bring her back.
That's what I think the closed hearing is about. This is last night. I was watching this and I'm like, oh my God, shots fired at literally Bill Thompson. Like, holy shit.
In the world, people joined in that applause. She's amazing. Just go on. When Mrs. Gonsalves, did you?
So I called Olivia and got but back to that room, and I was crying, and
I expect the prosecutor to lie to you, and we were.
They were going to get him. It was some kid. He went and he shot up the house or something, and they got him. He's walking down the street, and I just kept waiting for the news to say they've arrested somebody. And when Jack told us that, I was kind of like, ugh, this sounds a little different than what we're thinking. Type of murder.
Well, I mean, you're right, because we were all led to believe, Steve and Christy, that, they died in their sleep. That is not what happened at all, Steve.
Yeah. You don't expect the prosecutor to lie to you, and we were lied to, all the parents.
Oh my God, shots fired. You need to come join me tonight. This is crazy. Finally, you guys know I was saying it yesterday. I was like, dude, let the parents just speak. Don't cut them off. Don't edit their stuff. Let them tell you what they want to tell you. You know what I mean? And for the most part, that happened a couple different times. Nancy's being Nancy and just fucking has to interject. And then I was like, man, I wanted to hear what he had to say right there. Like, what the hell are you doing, Nancy? Shut the fuck up. But Steve unleashed. And I'm like, yes, I'm telling you, this is their best interview that they've ever done.
Parents were lied to. We weren't given the details. They're asking us to make a decision on life or death, and they're not even giving us the details of our own children, let alone the whole circumstance of what happened to them. I know for a fact that when one of the mothers heard what happened to Kaylee, she said this would have changed everything. So
yeah, they wouldn't have agreed to do a plea deal. They would have said, no, we're going forward with the death penalty.
it was disgusting, and they kept saying stuff like crime of passion and house or a party house. And we're like, what's going on here? I'm literally watching the surveillance of this Road, and this car keeps flying around this house over and over again. They were clearly stopped. I don't care what the prosecutor, maybe he can't prove it because he's just not that good, but they were clearly stopped. He was there multiple times. The officers were distracted with giving minors in possessions when they're literally filming the house that these kids get murdered in. I mean, that town has to clear up some priorities and realize that, noise complaints and alcohol is only a part of their job. And they need to make sure that they're protecting these kids if they want to keep doing business.
Yes. So fucking true, man. So true. And the people that are calling in noise complaints at 5:00 in the afternoon or 10:00 on a Saturday, fuck, why do you live there? You're living in a college town. Get the fuck out of there.
I was stunned when I heard plea. I want to circle back to something you said. We have no evidence. The King Road address. And Kelly knew she was being stalked. So that is a lie. You stated the DA lied to you. I believe that.
This is all. I believe that. And then my thing is like, you guys, if they're lying about this, they're lying about other things. Okay. Like, it's just, you don't just lie about one. Hey, we'll just lie about this. No. Fuck shit. The whole damn narrative's a lie. Okay. But
because there is no way all the parents would have acted like they were going along with this plea if they had known what we're learning now with all these videos and body cam and crime scene photos coming out. That is not what everybody was told happened.
Yeah, 13 incidents in WSU before this individual was let go or defunded.
I told you guys yesterday, Steve wanted to bring in, he wanted Nancy Grace to talk about WSU and their, like, what is going on? Like, what the fuck is their problem, basically? And so if you guys see, they're wearing the same clothes. Nancy Grace is wearing the same clothes. She just broke up the way that she was going to do this whole segment into two things. Who knows? Maybe there's a third, fourth. I don't fucking know. But, and the work and the research that I've done, and when I found out about all these parking tickets, I'm like, WSU had to know, like, out the gate as soon as you would have mentioned a white Honda Elantra, okay, and they were putting it into their system. This would have flagged. I mean, hello, it's just you wrote the damn dude a ticket on the 21st of November. He kept getting tickets. He got a ticket after, like, he got multiple tickets after the homicides.
Did whatever spin these universities want to put on it. This guy was a nightmare, throwing up red flags everywhere. And those are the type of details that we gotta force our courtrooms to be more honest. And we shouldn't be sealing things up in a case like this. I mean, it's not national security. it's getting abused. They're abusing these rules that they say, oh, we got to protect. They didn't have anyone to protect. They didn't even have the guy to tell almost 7 weeks, and they were still hiding
I
everything.
disagree with that. They had earlier than
So
7 weeks.
it was just a lie. And, you know, when you call them,
What were they hiding?
Learned the day of the day before the sentencing, how many times Kaylee had been stabbed.
Wait a minute.
I didn't know this. I didn't know some of this stuff. Like Kaylee was stabbed 24 times in the face, in the head face area. That's ridiculous. That's ridiculous. 24 times in the face to be stabbed.
A minute. I am stunned because she her. And you just learned.
We learned about it after the plea, the day before the sentencing, because they lifted the gag order. So the detective said that they would talk to us. So we talked to them briefly, and we had questions about Kaylee. You know, how many times was she stabbed? I mean, that's not on her death certificate. The coroner never told us. She just said around 20 is what she said. So we really.
Steve calls them out again and says, the only reason you told us that and you had a meeting with us is so that you guys could go on your little media tour. And I'm like, exactly. Dick.
Didn't know, and we didn't know where. So we asked them that, and they told us 38 times. And then we were like, okay. And they said Kaylee had really bad damage to her mouth. And I asked them if her teeth were intact, and they told me no. And then the day
to hear this stuff, you know, reading those reports, like Christy says it. Christy says to hear certain words now, like to use the term unrecognizable, like
of the sentencing, the docs were dropped, the Moscow docs were dropped. And the next day we were driving home and I was reading some of them, and I read that Kaylee was, unrecognizable. And that was that word will forever like traumatize me. I didn't expect that. And then to read another report that said the same thing, unrecognizable. And then to read a third report that said he wasn't sure what he was really looking at because the facial structure had been so badly damaged.
That's ridiculous.
So that's why we're disgusted with this prosecution team. I mean,
we did not know.
So that's why we're disgusted with this prosecution team. I mean,
we did not know any of that for 2 years and 9 months.
That's why we're disgusted with this prosecution team. So are we, Steve. So are we. Absolutely disgusting. Absolutely ridiculous. But I'm telling you, best interview. And ironically enough, I'll tell you what, Steve and Christy, the only people that could get Nancy Grace to shut up the way that she, you know, she did have her blurting moment. She was Nancy, you know, but to see them be able to talk and not be edited and cut and copied and, you know, all that crap, like their words can't be twisted, you know, they finally got to speak and it's just here. And so I'm grateful for Nancy for allowing them to come on her platform to speak, because her platform has 750,000 people. That's why it's so, you know, I go off and I go ham on, you know, when you have a platform like that and you're spreading the misinformation, like it's really bad. You know, you're not some 5,000 person YouTube channel. And it doesn't matter. Hey, we're going to have Sydney Sumter out there, whatever the fuck her name is. Sydney, if you need a new job, let me know. But that was the most reckless shit I heard yesterday.
We did not know that because of the gag order.
And they're telling us, are you okay with us giving them life in prison? We're like, no, we're not. And the people who are, they don't know what we know, and we don't know what they know. I don't know what happened to their child. They don't know what happened to mine. It was a protect the business over the victims, over justice. It was we're still fighting with it. I mean, we're still fighting with it to this day because we're hearing details that he was following girls out to.
All right. So yep, join me later. It's exactly what it was. And I think it was even more strategic than that with them. This was a protect. It's always been. Universities are always going to come first over there. That's why there wasn't a trial. The people that work, the jobs, the universities. So join me later. You guys all rock. My little Italian stallion. We have to do a live. When are you going live? I'll come over there. Are you going live today? Make sure you guys go over there and see Dago over there at the cafe. But this is on tonight. I think I have it listed already at 9:30 Eastern time. Yeah, I'll be live a little bit. Okay, I'll come by and pop on if you're taking callers. If not, I'll email you. But thank you, moderators. Again, from the beginning of the episode, you can go back and see what Hippler, he unsealed more than 30 of the documents. He's in the process now of, you got to go to the case of interest page, and then you can scroll down and you're going to see the little new icon next to it. Some of the stuff has been uploaded, so you can see it now, and some stuff hasn't. I expect those to be done today. So, all right, guys, we'll see you on the next one. Be kind. Peace out.